Director of Pinellas County. I'm really jealous that I just received flowers this morning. I'll forgive you. I'm here to provide some fair housing training for COCs and homeless shelters specifically. So this training is tailored to that community. I've been with the agency about 8 years. We do about 200 investigations a year in employment, housing, public accommodation. We do unincorporated and incorporated Pinellas, where we have jurisdiction. We have a memorandum of understanding with HUD and also EEOC. So when we do an investigation, it is like HUD or EEOC has done an investigation. In the 8 years I've been with the agencies, we have not had a complaint against COCs or homeless shelters and transition shelters. So I'm going to assume that you all are doing things the right way, which is good. And so fair housing protects the rights of all people from discrimination in housing. The Fair Housing Act applies to dwellings, and that's defined broadly according to HUD. That's any building, structure, or portion thereof which is occupied or designed and intended for occupancy and residence. So anything that deals with housing is covered under the Fair Housing Act. Even if there's a property to be developed, as it's being developed, it falls under the Fair Housing Act. The Fair Housing Act here covers most rental properties, include nonprofit housing, shelters, transitional programs, and housing as well. Any organizations offering rental assistance, vouchers, subsets, agencies that are operating counseling or placement programs, temporary or long-term housing shelters, clean and sober facilities, transitional housing, and motel, and even Airbnbs covered under the Fair Housing Act. So it covers anything to do with that, even advertising. These are protected classes in the Fair Housing Act. And so if you bring a complaint, it has to be in one of these categories. If you notice, what's not under Fair Housing Act is age. Yeah, it's not in the Fair Housing Act. But there's other ways to get to discrimination as it relates to age. Because you would imagine that there are many communities of 55 and older that would have an age community. So there are other ways to get to those discrimination issues under the Fair Housing Act. These are other applicable laws that cover housing. Section 504 deals with design and construction. Title 6, again, deals with the protected classes. It also deals with programs who receive federal assistance from the United States, from HUD. Also the executive order, which deals with the LEP, which is where person English is not their first language. They have access to housing. And anyone who receives federal funding has an obligation to make housing available for persons with language. English is not their first language. In the county, the way we kind of address it in the county is we have a 1-800 number for every county department who can call a language line service for interpretation, real-time interpretation of over 200 languages. So if someone comes in to receive housing and English is not their first language, they cannot be turned away. They have to find, if you're receiving federal funding, have to find a way to communicate with those individuals. Of course, the American Disabilities Act also covers fair housing. Title 3, which is the American Disabilities Act, covers disabilities in programs, services, and activities provided for any public entity. Have to be accessible for the disabled community. Covered programs cannot discriminate against persons with disability and must be ready and willing to make reasonable accommodation if you have to adjust your policies, your practice, and your procedures to make a reasonable accommodation. It may involve changing the physical structure of the building. You have to make public accommodations or reasonable accommodations for persons with disabilities. And we'll take a deeper dive down into that as we go through this training. These are the places that can be intended for residents. It involves a length of stay, the right to return nightly, what amenities are available, showers, bathrooms, beds, how the property is marked, written terms of occupancy, that's those who sign leases and things like that, rent payments, program fees, in-kind services. Domestic violence shelters are not necessarily covered under this because sometimes they're not intended for folks to return. But they can. So talk about how to make a fair housing plan. First of all, you have to have jurisdiction on merit, which means your complaint has to be associated with one of those protected classes that we talked about: race, religion, national origin, disability. You have to have be in a protected class. And anyone who is associated with someone in a protected class, say you work for an organization that you see that they have some discriminatory policy, you have standing to bring them. So those housing providers who assist members of the community to find housing, and they find out that when they take those persons to go into the housing, they're discriminated against. And we actually had one where it was a counselor who was assisting a person in housing opportunity. They made all of the arrangements, had furniture delivered to the apartment, had made arrangements to have a lease signed. And when they showed up at the property with the renter, who happened to be a person of color, they denied them access to the property. So the person who was their representative had standing to bring. They have to be filed within a year. And investigators are neutral parties. They don't represent the complainant or the respondent. A lot of complainants, charging parties believe that we're their representative and advocate. We are not. We are a neutral fact-finding organization. And it is on the complainant, the charging party, they have the burden of proof to show that there was discrimination occurred. Oftentimes, that's where complaints fall short, is that complainants don't have enough evidence. They may provide us with a list of witnesses to interview, and sometimes those witnesses are not helpful. And so we try to tell charging party, if you want to put somebody on your witness list, make sure they understand that they're going to be contacted by the Office of Human Rights, and they're going to ask them particular questions as it relates to your allegation of discrimination. If they can't support that, then they're not going to be really good to have them as a witness. And you'll be amazed how many times people put a witness list forward and they're not helpful. And we're obligated by HUD when we do an investigation, offer conciliation and mediation through the entire process. HUD has a mandate that we get cases, housing cases closed in 100 days, unless there's complicated issues surrounding that case. We have to get 52% of our cases completed. Common types of discrimination. When folks show up from different communities, we will hear, we don't take people. Our number one discrimination complaints that come into our office normally deal with disability issues, and then probably second would be the LGBT community. The LGBT community often isn't the provider of housing, but it's the residents or neighbors that are associated near the persons from LGBT communities. Making a misrepresentation that housing is available. We have testing programs. If somebody calls and they believe housing was denied to them because of one of those protected classes, we will send testers in with the same qualifications, the same standards to go in and see if they receive a different answer. failure to provide reasonable accommodations or modifications to a property. And then, of course, desperate treatment or impact having unintended consequences. There are some policies that are neutral on their face, but having unintentional consequences of affecting a particular class, protected class of folks. Where we most see that is in felons. Somebody has a no felony to apply. They have to be done on an individual basis, and you have to have a standard that applies to everyone who comes in the door. And arrest records don't count. It has to be convictions. So it says because somebody has an arrest record, it's not a reason to deny them housing. And when you're looking at particularly the felony community, you have to look at the entire record. It may have been somebody who made a mistake at 18 years old, in 20 years, they paid their time, they paid their time, they've been a good citizen, they hold down a job, they qualify financially, there's no reason to deny them. So I kind of just covered that. But in disabled communities, persons with disabilities, people might have rules there's no medical equipment. Of course, we know that that might have a profound effect on persons with disabilities who have to have oxygen tanks and wheelchairs and other medical devices. And some transitional shelters or homeless shelters may have rules in terms that if you're going to stay there, you got to go out and find employment. There may be persons in the disabled community that don't have the ability to go out and look for employment, so they would miss that particular standard. But remember, cases of disability, you have to adjust your policies, your practice, and procedures for persons with disabilities. Organizations receiving federal funding. If you receive federal funding, you have a mandate from the federal government to affirmatively further fair housing. That's the final rule. Requires all recipients, including COCs and emergency shelter programs, you have to affirmatively make steps and actions to eliminate any disparities of segregation or living patterns in housing. That's your obligation if you receive any federal funding. And that includes subrecipients. Subrecipients have the same obligation as the agency who actually applied for the funding and received the funding. They have the same obligation to not discriminate for reasonable accommodations or modifications. One of the ways that we do with our subcontractors with Pinellas County, we contract with contracts with mediators and also attorneys who will take our cause cases for us, and we make them sign an agreement that they follow civil rights law and that they don't have any discriminatory practices. It's just a way to protect yourself and the subrecipients who receive money from the COC or others or the alliance. That is a way to protect yourself, to make sure that your subrecipients who are receiving and benefiting from these federal funds will not discriminate. And if any of the subrecipients are believed to be involved in some discriminatory action, you must take corrective action immediately. That means document. Because if a complaint comes into our office, it gets to HUD, that's the first thing HUD requires. What did you do to eliminate, or what corrective action did you take against the allegation of discrimination? So it is incumbent upon you, if you have subrecipients who receive that funding, to make sure that all of their staff is trained. And we're available. We will train and we will travel. We have the staff of people who will go out and do that. So anyone who is receiving federal funding, you have to make sure that they understand fair housing law. And if that is not the case, you jeopardize your funding. And HUD has snatched funding from organizations. The equal access rule. It is to eliminate any criteria that tends to screen out persons with disabilities or the LEP community, where English is not their first language. They have to have access to your programs. If you are advertising them, you have to make sure that everybody has equal access. That's to ensure that your programs and your facilities are accessible. If you have doors to your facility, the ADA and the 504 Rehabilitation Act says that those doors have to be open with a minimum of 5 pounds of pressure. You can imagine, and we get this all the time, persons who are in wheelchairs and the doors don't have the automatic openers or they're too heavy, that'd be a violation of their housing law. So you have to make sure that they have be able to physically assess and access your property. If you have a person who are deaf and hard of hearing, you have to have a way to communicate with them. That includes bringing in ASL interpreters, doing whatever you need, having some equipment that amplifies sound. If someone needs that accommodation, you have to be able to make those accommodations for persons with disabilities. We had a gentleman, this isn't housing, but to show you how you have to have this equal access rule. There was a gentleman who was deaf and hard of hearing, went to a fast food restaurant, drove up to the window, he was deaf and hard of hearing, and tried to hand the employee a note of their order. And they said, we can't take your order that way. You have to do it with the speaker. And he tried to explain to him that he was deaf and hard of hearing. They called the police on this. The police said, can we place the order for the guy? And he said, no. So he filed a complaint in the office. Needless to say, we found calls. We went out and provided training for them, and he also won a large sum of money because they did not adjust their policies, practice, and procedures to give accessibility to persons with disabilities. So again, HUD requires all programs to be made available to individuals and families regardless of actual or perceived sexual orientation, gender identity, and marital status. And we'll take a deeper dive into that as we go. That's the equal access. HMNIS anti-discrimination laws. Questions about a person of disabilities or that might reveal the sensitive nature of that person's disability is not permitted. And we're going to give you some suggestions and some hints on how to ask a person if they are disabled. We're going to give you some hints and suggestions and some best practices on how to address those kinds of issues when you need to. When you do an intake process, of course, we know there's a series of questions that you're mandated to ask, but we want to make sure that the person understands that these questions are only to ascertain information that will give you access to the shelter. That we're not dipping in your business, we're not trying to find ways to eliminate you, but this is a procedure that we undertake because it is necessary for us to give the information to provide the proper assessment that will give you access to our facility. So that criteria for access to any shelter, any housing provider, you have to make sure that that criteria is clear, it's objective, it's consistent, it's a standardized form and screening that applies to everybody. And it's based on fact. We talked about arrest record versus conviction. They have to be based on fact. It can include rental history, it can include income, and also observable behavior. Recipients might show Shelter Plus Cares, may establish preferences for certain programs. Most of those deal with serious mental illness, alcohol, AIDS, HIV program. They can have preferences for those particular services. So if somebody who does not have any one of those particular special needs, and think that they've been denied housing because they didn't gain access into the HIV and AIDS, we can have some statutory limitation because that is a specialized program. Here's where discrimination can occur, and it's literally through a whole process. It can occur during the application process, steering people, segregating people based on their protected classes. When you advertise for housing or shelter, you can't advertise preferences. And this happens in the private sector. A person is looking for a roommate, and they say, I'm looking for a white female roommate. That's a violation of fair housing. Can't advertise preferences. And I'll make that clear that happens. You look for different terms of conditions and treatment. That's whether it's procedures, rules, rent criteria. We recently had a rent criteria complaint where, and most of you will know this, renting places require 3 times the income in order to qualify. This person was a single individual, and all of a sudden they had to have 4 times instead of 3 times. So that's a different term. And that's a complaint. So any fees, charges, repairs to common areas, which means if there is something in a common area, a laundry room, a cafeteria, lunchroom, and then this has come up too. Some people might have a cafeteria or lunchroom space that's not large enough to accommodate wheelchairs and allow them to stay in the dining hall. You have to allow the person with the wheelchair to come into the dining area. If you can take the wheelchair and then set it outside. But you can't say, hey, you in the wheelchair, you don't have to do that. Have to make those modifications. So we already talked about establishing rules, target specific services. You can't harass, threaten, or force an individual, and termination and retaliation is also part of violation of fair housing. And when somebody files a fair housing complaint, they move into what we call protected category. That because they have the right to file a complaint about what they believe to be discriminatory practice. And we have had a landlord said, well, we really ain't gonna do nothing now since you filed this fair housing complaint. Guess what that is? Retaliation. That's against fair housing. So prioritizing applications. In general screenings, sometimes yes.
Saying 4 times the rent,
yes,
what the standard rate is. As a complaint or a tenant or applicant for that property, it would be their responsibility to identify other tenants or applicants that were only required to pay or to make three times the rent.
Well, they can file a complaint on the face of the complaint.
Yeah.
They know some friends, they know some other folks who have had access into the property. And in fact, they refer me to the property and said, you need 3 times the income.
Okay.
So if they file that complaint, if they don't have witnesses, we're still gonna go in and we're gonna ask, let's see your application, let's see what your criteria is for everybody to gain access.
Yeah.
Yeah.
So if the property was able to say, because your credit is lower, we require 4 times, that's something that they would be allowed to do, or? It
would have to apply to every.
Okay.
You know, I mean, it couldn't be specific to one person or another. Okay. They would have to demonstrate that they have a reason to have a rule where certain folks have to have 4 times a year. And it could be they had an eviction, an eviction on their record. They could be this, that, or the other, but it has to be across the board.
But for the complainant, say Halo went somewhere and she got in with 3 times the income, and then we think we have about the same credit, we don't know for sure. Yeah. So then if I felt like they told me 4 times for no reason, then I should still file a complaint, or like if I get that high.
Yes,
okay.
You can. Now, all things have to be equal. So that, to your point,
Right.
you have to be able to meet the, like the history of not having any eviction, not having any criminal record kinds of things, and anything that would eliminate that process. But all things being equal, one person has to have 3 times. They're single, they apply, they gain access. I show up, I'm single, I'm just of a different race. I have about the same income, and I was denied or had to 4 times the rent criteria. We want to know why. Local.
Okay, that's fine.
Yeah, they're local and guidelines.
Okay.
And when the rents start going skyrocketing in our area, particularly in Florida, a lot of municipalities are beginning to scramble to come up with ways to assist us citizens with escalated rent. They put some local things in place. They try to help the citizens, and the governor issued some guidance that eliminated the local protection for rent. So then because the state trumps the county, the federal government trumps state. So sex discrimination, again, is illegal for providers to segregate folks out based on sex as it relates to shared sleeping areas, bathrooms, and that is a standard practice of the shelter. You have a woman's side and a men's side, and you have it that way for privacy concerns. Then you can have those rules, but you can't segregate folks out for other arbitrary reasons. You cannot mandate sleeping arrangements in individual units. You can't restrict boys or girls from sharing the same bed. It could be just a 2-bedroom unit. I got 2 children, and your landlord or whoever might have a problem with a boy and a girl sharing a bed together. You're overreaching. That would be discrimination, I don't think, in sex or familiar status. The Fair Housing Law does not allow providers to dictate sleeping arrangements. And culturally, there are certain cultures who believe in bed sharing. And so when you be like, hey, I see a spot of y'all, we got 2 bedrooms, but how y'all gonna handle it? You're overreaching. It should be based on square footage, and things like that. And if you have any questions, because there are a lot of landlords who might have a 2 heartbeat for 1 bedroom kind of situation, and a married couple shows up, they have an infant, and they said, well, we have a policy 2 heartbeats for 1 bedroom, and we don't have 1 bedroom, and they had a 4-month infant. And they said, I see you got 3, but the baby can fit in the rest of yours. Don't eliminate us because, but that has happened. So you have to do that. Familiar status or from anybody who has custody for children under the age of 18 cannot be denied. And again, that includes sleeping areas. The separation comes when it's a single individual apartment or it's a dormitory situation with cots. Then you might be able to have some restrictions in place. We talked about housing design for older individuals, but there's a specific law surrounding communities or for older individuals, like your 55 and older community. It has to be posted outside of your property, and any advertising that goes out has to state that you are a 55 and older community. And some of you may or may not know, just because it's a 55 and under community don't mean that they have people in the property that are under 55 years old. There are plenty of grandparents who are raising children now. The caveat is that 85% of the folks who live there have to be over that age group. And if they have that number of 85%, then there may be someone in the community who is under the age of 55. There are some communities that you can discriminate against, yes.
I've heard that 85 before. Is that, like required, say if a community has 0% and grandparents trying to move in their grandchild, would they then have a case because of the 85%, or could community remain at 100?
But they're at 100%, and there's no other way to bring anybody else in the community there except someone 50%. The threshold is that if they are at that 85% and there is a grandparent or a foster care person who's taking a child to the age of 18, that they then can be permitted to the property. So there are some communities you can discriminate against, and that's folks who've just been released from correction institutions, sexual offenders. You can discriminate them, particularly in housing for families and children. You can discriminate those folks, and we'll take a little deeper dive into that too. But if you have any questions, also always check the legal answer or give us a call. All the So when you have families in your shelters, avoid having rules saying that adults must supervise children at all times. Children under the 18, 15, 13 years old don't need to be supervised all of the time. So you want to avoid rules that say parents who have children under 18 need to be supervised all the time. It's not appropriate to have a supervisory role for over teenagers. Teenagers are often commonly used in communities for babysitting and other reasons. So it's important to know that you can't have that kind of arbitrary. There are often times that parents have medical appointments, legal appointments, and they have to leave their children attended for a little while. They ought to be able to be permitted to do that. CPS has standards of when a child can be left alone. And generally they don't recommend the children under 5 be left alone. So if you have any questions or more than 3 hours, if you have any questions, certainly reach out to CPS. If somebody is continuing to leave their minor children alone.
Yeah.
So these are kind of common rules that apply to anybody in the housing situation. Damage is damage. If somebody creates damage to your property, the shelter, you can charge folks for that damage. You must allow common areas to be used by all folks. You can't have certain areas of your property that you want to exclude children. You don't want to have a kid-only curfew, because then you're going to have to designate what kid is 15, 16, 17 years old. So you just have to go there. Again, follow some industry standards when it comes to safety and health of your facilities, like pool, fitness areas, and places like that. You may have some limitations. You don't want a 6-year-old kid working out on the fitness equipment. That's not. So there are certain places safety that you can have certain rules that restrict children's access. Yeah, we talked about this a little bit earlier. Sex offenders, these are not protected under fair housing law. Current illegal drug users are individuals who are not covered. Those individuals who constitute a direct threat to themselves or others can be eliminated from your property. For persons who have disabilities, and their threat can be mitigated by the use of medications, and those violent outbursts, things like that, can be controlled under the medication. And you can tell when Joey on medication because he's acting a little stranger than he normally does. You say, Joe, not on your meds, or are you on your meds? Make sure. The rules can't be arbitrary. We had a situation where a woman was at a homeless shelter, and she obviously had some mental health issues. And she would just stand out in the hall and stare. She wasn't saying anything. She wasn't doing anything, but it made people really uncomfortable. And they asked that person to leave the shelter. Violation. that they're not a direct threat, sales or others. Can't exclude them just because they make it. We're going to talk about disabilities right now in this section here. Any questions on the stuff that I've already covered? So, for persons with disabilities, you must comply with non-discrimination requirements for prohibitions that exclude, segregate, or they receive unequal treatment. We've had housing complaints filed for folks who had service animals or emotional support animals moving into a housing complex, and they had a set of units that are designed for persons with pets. Someone comes in with a service animal, they want to put them in the pet-only area. That's against the law. Because they're not a pet, they're an assistive device to aid them with their disability. Let's see. Architectural standards, I already talked about that a little bit. And you want to make sure all areas are accessible. There's a standard in buildings with wheelchairs that the doorways have to be at least 36 inches to accommodate a wheelchair. So if you have a doorway to a common area that is smaller than that, you have to make that adjustment. And it's those things that are easily achievable and not too expensive. There is a thing that things can be an financial burden. But we've had situations where somebody lived on a third floor unit, they had mobility issues, and they were requesting to have an elevator put in the building. And that would have been an exorbitant amount of money, so it had a burden on the institution to provide for that accommodation. You don't have to do it. But those things that are easily achievable and can be easily done with not much expense have to be done. Have to be done for public accommodation. Again, you have to be able to effectively communicate with persons with disabilities, whether they have hearing, vision, or speech disabilities. You got to do everything in your power to communicate. Here's what you can do. A person is deaf and hard of hearing. They bring a friend or relative with them to gain access. The person who is doing the intake is having some difficulty communicating with the person with a disability. You cannot ask, can your friend help me fill this paper? They can say, can my friend be allowed to help me? That's different. But you can't ask. That makes sense? Okay. Because you all see this situation, it's going to sound a little bit benign, but you see persons with disabilities, accompanying persons with disabilities who are completely capable, and they end up talking to the person without the disability instead of addressing the person with the disability who has the ability to answer the question. So, who is a person who's disabled? Is someone who has a mental or physical impairment that substantially limits one or more life activities. So what are more than life activities? They are the things that we take for granted: seeing, hearing, walking, taking care of oneself, and learning. If you have one of those, then you qualify the person with a disability. And again, someone has a disability, you have to adjust your practice, policies, and procedures to accommodate those folks. Give you an example, just in the county, one department had to have a test for a person who was deaf and hard of hearing, and they had to provide an ASL interpreter. And the person was flunking the test. And so they called us and said, how we got to provide this ASL interpreter when the person keep coming in and flunking the test? As long as everybody else has an opportunity to take the test. You have to provide that information. You have to have equal access. Make sense? And yes, it's expensive. Yes, it's a hit on your budget. But if you receive federal funding, guess what? You don't have a choice. Yes. Yeah.
I just want to clarify, are we talking about short-term, long-term, or both types?
That's a great question. It is, you can ask the question, is this a long-term disability or short-term disability? You can't ask that question. Here's a real simple. This happens at the county too. Someone comes in and they receive services, they wear glasses. And they say, oh, I left my glasses at home and I can't see this application. Can you assist me? They have what? A physical impairment that substantially limits one of life's major activities, because seeing is a major activity. And so a lot of county departments have readers. They here, but if not, one at 8. But the individual has to be recorded of having such an impairment, and then they have to have a record of having that impairment. We'll talk about that a little bit more, take a deeper dive. Any questions so far? All right, so housing providers are entitled to verify the existence of a disability, particularly when that disability is not readily apparent. Somebody comes in with a dog, with a brace, and a vest, wearing dark glasses, and a red tip cane, you don't have to ask that person, are they a person with a disability? But if they're asking for an accommodation and it is not readily apparent, you can ask particular questions. Now, here's what happens in those instances. If you've ever dealt with somebody who is a qualified person with a disability, one of the things that they are extremely sensitive of is that when you're asking them about their disability, that's a violation of HIPAA law. You have no right to be here to ask me about my disability and what that's all about. So there's a way to get past that by simply asking. They're asking for reasonable accommodation. They don't have to use the term reasonable accommodation, but you understand it and you take it to be so. You merely ask them which major life activity is impacted by your disability. I have problems walking. I have problems seeing. I have a learning disability. That helps you get past that. Okay? And then if somebody says that they are a person with a disability, take it on its face value. Don't go to dig. Now, you can ask for documentation for reasonable accommodation, but that documentation that is prevented by this, and we'll talk about the end part. Here it is right here. The people who can provide some documentation are physicians, psychologists, social workers, veterans, assistant folk can provide documentation to substantiate that persons have disability. It does not have to be a physician. What it cannot be is your brand new internet doctor you met the other day. They have to be a third qualified party. You got a question for me?
Yeah.
Yeah.
With that, like the service animal most important, like their homes at that time, like they may not have that documentation on them right away. Can they still be denied services, or are they probably get like services?
Well, yeah.
Like,
Well, again, if it's not readily apparent, they have to have that documentation. You don't want to make an accommodation without the documentation, because what's going to end up happening is you made a different terms and conditions for somebody else who shows up. You know what I'm saying? So they have to have that documentation. So here's again how you deal with service animals and emotional support animals. And there are differences. Service animals are the only ones that are recognized under fair housing law. Emotional support animals are not. They don't have the same access as emotional support. Service animals can go anywhere the person with a disability can go. An emotional support animal doesn't have that same level of access. Say there's a facility and they're taking a field trip for the day, and a person gets on the bus with their service dog, and then the person comes in with their emotional support parrot, and want to get on the bus, that parent isn't allowed on the bus. Take that thing back up to your car. Service animal or anywhere the person with disability. And so again, how we get around that question? Asking folks about not only are there personal disabilities, but is this, how's the service animal helping you out? So you ask this question: has this animal been trained to assist you with your disability? If the answer is yes, the service animal status. Don't say demonstrate that. Had a dog go get your refrigerator, you can't do that. Also, what you need to know, there is no national clearinghouse for service animals. Anybody can go online and pay $50 and get a service animal certificate. It needs nothing. Service animals have to be trained to aid a person with their disability. Can a person have more than one service animal? Absolutely. Depending on which animal for which part of your disability age. You get that a lot. So, person comes in, they have a dog. What's the other animal that qualifies under federal law? Miniature horse is the other. So those are the only two. They don't show up. They show up with something else than a dog and a miniature horse. You can ask them some different kind of questions. They have to provide that documentation. So how do we deal with that? Are you a person with disability? Yes. Question answered. Moving on. How is this animal been trained to assist you in that disability? Will they aid me involved? They alert me if I'm going to have a seizure that's about to occur. Don't again ask them to demonstrate. Okay? You want to ask them to have a seizure, so you can say. So what verification do we need? We need a verification from a medical doctor, a professional, peer support group. It could be an AA, Alcohol Anonymous group, to show that those persons are indeed a person with disability. Then they have to note, has to describe the need for the accommodation. It has to be a nexus. I can't have a bum leg and I need help with my vision. It has to be related to my leg. And so, again, persons, if it's not readily available, is when you ask those questions. Somebody comes in with a bum leg and a cane, you want to ask them, are you a person with a disability? What is it I can help you today as it relates to your disability? Well, I need a parking space closer to my apartment, my unit. Is it short-term or long-term disability accommodation you're going to need? Now, with that request, talked about this already, if it is you receive federal funding, you got to make that adjustment. We get this all the time. Somebody who might live in a building on the 3rd floor, at the time they were not disabled, and during the course of their tendency, they become disabled. They have mobility issues, and they make a request for a 1st floor apartment unit. But they have difficulty getting up and down the stairs, an elevator, etc. You have to make that accommodation. Guess what? You don't have to kick somebody out on the person. You got to wait till a unit becomes available. And for the persons with disabilities, often get impatient. So, and believe me, they got watchdogs. If a 1st floor apartment becomes available and somebody else moves in, you got a problem. So you want to make sure. And if there's a list, you know, because they may not know, you already have a list of folks who have already made a request for disability to have a place for a unit, make sure that they understand. Okay. So the note should explain and have a nexus why you need that disability. And you must be able to explain the relationship between the disability and the need for the accommodation. We had a situation where a person purchased a home in a community that did not get access to flatbed trucks. And this person had an eye removed because of cancer. He had a flatbed truck, and they bought a home in a community. And so they told the person, listen, there's nobody in our community that big. It's against the rule. You don't have it. But we're going to encourage you to buy in another community. And many people have done that in the past. They found out we got this truck move and they moved into another community. And then she provided the documentation from the doctors who approved the nexus. It was for their field of vision, so they wouldn't have any obstructions. And then they said, well, why can't you get an SUV that has the same height as a flatbed truck? But needless to say, there's now a flatbed truck in the community because you have to adjust your practices, policies, and procedures to accommodate persons. Now, if a person with disability makes accommodation request for something to be done in their unit to give them the full enjoyment of their unit, whether it's grab bar or some other situation, if you receive federal funding, it's your obligation to make those accommodation changes. If you don't receive any federal funding, you can ask the person who made your accommodation request to pay for those changes. And then you can also ask them, if it's not a benefit to maybe the next person moving in, that when they leave, they restore the property back to its original condition. Any questions on that? Oh, when somebody comes in and makes a reasonable accommodation request, it doesn't have to be in writing. They don't even have to use the word accommodation. Again, I got a bad leg, my parking space is too far away from my apartment, I can't walk. That you don't have to say, so are you making a reasonable accommodation request? No, you say, how can I help you? Now, again, we don't have to kick people out from a parking space that's closer to their unit. We have to look and see what other kind of accommodation we can come up with. And we had this situation. This particular apartment unit had a handicap parking space for visitors that was close to the apartment of the person with a disability. And so they would park their vehicle in the visitor's disability parking space, and they were giving the person violations and notations for parking in the disabled parking space because it was designated for visitors. So, so and each of them had 2 parking spaces. So the accommodation was, okay, we'll allow you to pay for the striping of the unit, the parking space that's reserved in your unit to accommodate handicap. So you can get out of our visitors parking space. And the person did it. They brought people in, painted the stripes in, and now they have a parking space closer to it. Any questions? Oh, I only want to make one more thing about the service animal before we move on to the break. We already talked about there's no certificates. Service animal doesn't always have to have a leash. You know, many units will have a leash law. And if a person with a disability doesn't have the ability to use their hands, guess what happens to that leash law? Goes away. I was in Home Depot the other day with a big, huge gentleman picture that didn't have a leash. I'd have been a whole lot more comfortable if that gentleman picture had a leash on. But as long as they can be controlled by voice commands, they don't have to have a leash. Okay. Oh, and before we get this wrong, you know how properties have pick up your animals too, right? And person has a search dog, doesn't have the use of their hand, and that dog takes a poop in an area where they're not allowed to poop. They would send them a violation because you didn't pick up the dog's poop. I asked them, do you want the person to fall out of their wheelchair to get the poop? There's got to be some kind of accommodation for that person. Does that make sense? You have to adjust your rules and policies to accommodate a person with a disability, but they must be reasonable. You can't have something that is a fundamental alteration of your business. Now, I'm a housing provider. A person becomes disabled and the mailbox is quite a distance away from their unit. And they say, I'm disabled now. And I don't have the ability to go to my mailbox to get my mail. Can you get one of the maintenance men to do that? No, we're not in the mail delivery business. We provide housing. Ask your neighbor. So if it fundamentally goes against what you do, you don't have to provide that accommodation. Make sense? Yes.
Using that kind of same example, would it be reasonable for the maintenance man to have to go and clean up the dog's poop because the person with a disability physically cannot do that? So at 9 a.m. every day, 5 p.m. every day, the maintenance man goes through and does sweep. Would that be reasonable?
Yes. Now, yeah, let me tell you, be careful. You need to make that decision, whether it's reasonable or it's a fundamental alteration. Because here's what your maintenance man does, particularly if you maintain the lawn. That's not outside the scope of his work. There's poop in an area where you generally clean. So be reasonable. That helps. And believe me, folk all the time try to find reasons not to make accommodations for a person with disability. And I'm telling you, folks in the disabled community know their rights. That's why they're the #1 complaints we get in our office. So again, if you have a service animal, emotional support animal, all fees and deposits all go away. The extra $200 that they have to have if they have a pet does not apply in those situations. Any question?
Emotional support animal, is that the fee for renting? That's only for federally.
No, again, I want you to be reasonable. If somebody has an emotional support animal, you can't waive it. Okay. Because the better question is, what is it going to cost you if you don't?
Right.
You know what I'm saying? Because you leave a window or a door open. And that's why when you go out in public and you see the signs on the store windows, service animals welcome, emotional support animals, and you see people walking around in the store with their dogs, you know they ain't a service dog. But they said, listen, it's better.
Right.
To just let the dog go. Instead of, everybody coming in and saying, or you're a person with a disability, how this animal trained is put, so they just let go. Yes.
Not people their animals, they can't be done.
Absolutely. Let me be clear. I said earlier, damage is damage. If your dog is creating damage or your animal, they're responsible for those damages. Absolutely. If the animal is being disrupted, here's the caveat. Somebody comes into your building for service and they have a service dog. The service dog is being disruptive. You can ask the person, can you bring the dog under control? If they say, ain't nothing wrong with my dog, then you can ask him and the dog to leave. But you first have to ask them, we're going to ask you to remove the dog. You can come back in and receive the service, but can you remove the dog? If they refuse, then you can ask both of them. Okay. And here's I'm gonna put this caveat too. And we've kind of gotten away from this. There's always an opportunity for us to demonstrate our humanity. And this literally happened. A gentleman was paralyzed with waist down. And because, you don't have an obligation to feed, provide medical assistance to other folks with disabilities. But this gentleman was paralyzed with waist down, went to the restroom on himself, went all out on the floor. That's a chance to exhibit your humanity. You don't say, hey, go home and get yourself. You can say, look, can I give you a few minutes to go and address the situation? Somebody comes to your place of business with a service dog. It's a hot day in Florida, and they tell you they walk there and they ask you, can you provide some water for my dog? You see what I'm saying? So there's opportunities to display our humanity. I don't ever do a training without providing that. There are some folks who are so dead hard on the rules that they miss an opportunity.
Appreciate that, by the way. I love that, because it turns into, I have my own disability, but I'm not really needing much accommodation, but I do live with people who do, and but I caretaker. And it is amazing how often, especially like just lay people or even professionals have over professionalized it to where it's like, you've got to understand everything about this for someone just to play soccer. And that has nothing to do, and the disability has nothing to do with that. Or that we need to have some special program here, or can't get, now I have had an issue where I couldn't get into an emergency room in a local hospital because I was using a walker.
Public accommodation.
That was a big, you would know, but yeah, that became a big deal. But yeah. So I appreciate that, because I think we lose sight of the community and just our humanity
And
too.
you're absolutely right, because it comes up a lot in restaurants. When it comes to service and canes, you know, or wheelchairs, you know, wheelchairs obstructing the movement of the waiters to get around. And then it's, listen, you're gonna have to go and take the table outside of, you know. So, yeah. So again, reasonable modification or any change to the physical structure. We've already talked about it. If you receive federal funding, you're obligated to do that. That's providing a grant, whatever that is, you have to provide that on your own document. But if you don't, then if a person is in a housing situation and need a ramp, you don't receive federal funding, they have to pay for that. So if we talk about this a little bit, exceptions to our RAs are undue administrative burden and also financial burden. I talked about how somebody might need some assistance in filling out some paperwork. You got a long line of folks who are waiting to be served, and you ain't got 2 people on staff, and you really don't have the time to sit there and help one person. You can say, you know, we're really busy right now. Can I give you a better time to come back to receive this service? Versus saying, listen, we too busy. We got to come back at another time. So having an undue administrative burden is a legitimate reason not to make a reasonable request. And the other one is the financial. And we already talked about a fundamental alteration of your program. So we'll talk a little bit about the LGBT community, transgender community. The law protects folks from the LGBT community. Gender identity and gender expression is protected under federal law. It's actually signed by executive order in 2012 by President Obama, and later Biden added it. So a transgender person is someone who presents or identifies with a gender expression that is different from their birth. It can involve many aspects, from appearances to behaviors that are typically not associated with a person's gender. A person does not have to have gone through sex reassignment surgery or hormone therapy to receive that benefit in the transgender and sexual orientation community. What do you mean by that, Jeff? I'm presenting as a woman. I'm going to a shelter for women, and I'm looking for shelter. You better not ask, have you had surgery? Or you on hormone replacement therapy? Here's where it becomes tricky. I'm a male, I'm presenting as a female. I'm coming in to receive services, and I want you to address me by Sally. And in order for you to do the intake, we need an official's driver's license or ID, and on that ID has a different name. You can say to the person, Sally, respect, you want it to be addressed as Sally, and I'm going to do that, but for the sake of finishing this intake, I have to use your official. Make sense? I'm classroom, but this is an issue. Transgender folk are welcome to use bathroom and shower facilities. They could make a request for privacy reasons. If you could provide them some sort of accommodation, that might be a petition in the shower. That might be that they use shower and bathroom in the office space area. For privacy reasons, you can make that adjustment. But we can't deny them access. And also hopes that the provider will make a decision on eligibility, whether to place a person is on how that person identifies. And not how the intake person think they are identified. They expect you to be that sensitive. Now, again, if there's health and safety concerns, then you can make some decisions based on that. But you still have to accommodate that person when they come. And this has happened. Transgender persons have shown up at female shelters, and the people who were the head of the shelter made a decision to make another accommodation by placing them in the hotel. They could do. And we know that's an additional cost, but that's something that they would do. Some even allow them to use our office space for sleep and have some privacy, which you can't deny makes sense, yes.
That example, that there was, you know, male and female bathroom in a public space, and the person chose the restroom that coincides with their gender expression, how does the property handle that? If there was someone else there that not the property, so, you know, if anybody disagreed with that, how is that?
I'm going to go back again to an opportunity to visit, and I actually saw this online, which was amazing. The mother was her teenage daughter in the restroom. She knows a transgender person is coming in the restroom. She stood in front of the door, blocked it. So you want to wait. You ain't going here. And the transgender person was insisting, I have right and access to the restroom, which they do. Here's what was missing for me in that whole scenario. Depending on how bad my teenage daughter had to do restroom, I might say this, you go first. Or if I'm the transgender person, I understand your concern, I'm willing to occupy. You know what I'm saying? But you can't deny it. Make sense? We have really lost the fact that we sense it. It's happening. I see it every day. I already talked about it. If the transgender person expresses some concerns and says health and safety reasons why they want things to be a certain way, let's just try to accommodate it as it's feasible. Or this is a big one. Sometimes you have to take a drug test like going in there, you know. And you weren't there, you gotta give it in the cup. You gotta urinate in the cup, that's all I'm trying to say. There may be some privacy concerns, you know. So you just want to be sensitive. Again, it's our rule in our policy. You have to leave the door open, there has to be a staff member available in the restroom. All of that's good. Just find a way to be sensitive. So religious discrimination. Religious organizations are exempt from discrimination law if they have properties for rental or occupancy for their members only. So they can discriminate on that basis. But even then, if they have a members only preference, they still can't exclude people based on those protected categories, race, national origin, and those kinds. But they can say it is for members only. And we had a case where a husband and wife were living in a religious community and they got a divorce, and the woman was a member of the church and the husband wasn't, and he wanted to stay in the property. They're like, you ain't a member. You gotta go, but your wife can stay. And again, they're exempt from discrimination. So they can do that for members only, as long as it's not violating protected classes. So just to do a review, we're ending up here. So review all of your policies, procedures, rules to the application process and criteria to make sure that what's embedded, there's not embedded in that some unintentional discrimination. So look at your disability question, look at your race question, and make sure that there's not an opportunity for discrimination to be declared in disability. Be very clear what the requirements are to not discriminate against persons in a protected class. Establish consistent protocols that apply to everybody across the board. Make sure your employees know how to document any issues that could possibly relate to a fair housing violation. Because I'm telling you, when we come in to do an investigation, we're going to ask you, once this came to your attention, what did you do to eliminate the discriminatory practice? We retrained our whole staff. We called off human rights immediately, had them come in and provide fair housing training for our staff. This doesn't happen. And again, make sure your folks receive regular fair housing training. If you don't know how to address the issue, seek out technical advice. Again, call me at Office of Human Rights for guidance. Many people do. Be sure to develop a regional accommodation policy and that all of your staff is aware of the intake process on how to deal with a person, particularly for those disabilities that are not readily apparent. Whatever you do, don't say no to a reasonable accommodation without doing your due diligence. Asking for the doctors, looking for the nexus for the disability. Asking the question, is this a long-term or short-term disability? And then do an assessment of your facility and make sure that there are no architectural barriers that prevent a person with disabilities to have access. Any questions? You can email me. Oh, I got Paul's email. Still, ain't that crazy?
Send it out.
Okay. And I also left some fair housing pamphlets on the table. Be sure to take one of those. Yeah, if you haven't already, and take a couple if you want to take some back to your agency. Grab a couple of. We have Spanish and English. But my email is just Lorick at Pinellas.gov is my email. Any more questions? All right, again, I'm here to help. We're here to help. I'm from the government and I'm here to help. So again, thank you for your time. Thank you for the invitation. And enjoy the rest of your day.
Thank you.